Hi, welcome to our video. I'm Carl Shusterman. I'm an immigration attorney, and this is
Giselle Sotelo. I'm also an immigration attorney who works for Carl Shusterman.
And Giselle is one of two attorneys in our firm who specialize in deportation defense. Giselle's been in court hundreds of times here in Los Angeles.
That's right. And
she's won some major victories, including a recent one in the Ninth Circuit Court of Appeals. Today we're going to talk about a Supreme Court decision that's probably the most important immigration decision in the last 40 years since I've been practicing immigration law. And unfortunately, it didn't get a lot of press because, and you're a former journalist, right?
That's right. And the reason to be quite honest, the reason I don't think it got a lot of press is because so much is going on right now in immigration.
Mm-hmm.
And the Supreme Court has issued a major decision on Trump's travel ban. So that obviously took precedent among many people. And I also think the way that this new case is being interpreted very expansively, and it could help a lot more people than I think initially was thought under the actual ruling. So I think that's why maybe as immigration attorneys are interpreting this court case and finding that maybe there's a potential to even stop and reopen old deportation orders, that the more and more we know about it and the more interpretations there are, that it's becoming a bigger and bigger case. It's an evolving case, I think, at this point. And then, of course, we do have news coverage about the family separations and detentions, which I also think is the reason it's not gotten a lot of press.
How many people in the country are currently in immigration court that the government's trying to deport?
Well, according to you, 700,000 is what you told me.
And if interpreting the Pereira decision broadly, how many of those 700,000 would it affect?
Well, we don't know the exact number of cases where somebody has potentially accrued 10 years of continuous physical presence, who are in immigration court proceedings. But a very large number, I think, who were prevented from applying from cancellation could potentially benefit from this case.
But let me ask you, and I'll have you go through the specifics of the Pereira case in a minute. But let's say I was put into deportation proceedings a year ago, and I've only been in the country 2 years. Are you saying that it wouldn't affect my case?
Well, at this point, let's say if you were put into proceedings, you said a year ago and you've only been here for 2 years, right. At this point, it could affect your case, and that's what immigration attorneys are trying to argue, right? So what immigration attorneys have said is that it not only makes you eligible for cancellation of removal if you have the 10 years, but even if you don't have the 10 years, you nevertheless may not properly be in immigration court proceedings, and the judge does not have jurisdiction over you or jurisdiction to remove you from the United States because of the way of the language that is used in that case, which says that if you were served with a notice to appear that does not specify the time and place of your court proceedings, then that is not a notice to appear. And in order for the immigration judges to have jurisdiction over you, a notice to appear must be properly filed with the immigration court. And if there was no notice to appear that was filed, because the Supreme Court says in the case that a notice that does not specify the time and place is not a notice to appear, then that really calls into question whether or not jurisdiction ever vested over you and whether or not the judge can actually order you removed from the United States. So many immigration attorneys are at this point arguing that their clients' case should be terminated. So even for people who don't have the 10 years, right? So their case could be terminated.
What percentage of these notices to appear actually list the time and date of the hearing?
I would say, according to the opinion, Justice Sotomayor said that the government acknowledged that almost 100% of notice to appears that have been issued in recent years do not specify the time and place. They normally say And almost all of the ones that I have seen say, when it says ask for the time and place of the proceeding, it generally says to be set, which is not enough to constitute a notice to appear under this case.
So if someone came into your office and they showed you this notice to appear and it didn't have the time and date, so that wouldn't be valid, right?
Right. We
And
would argue
so,
that it's
so
not
you,
valid under
so you
Pereira.
could go to immigration court and say terminate the hearing judge.
Right. The judge, you do not have jurisdiction over this individual because this was not a notice to appear that was properly filed with the immigration court, and so you must terminate proceedings, and you cannot order this person deported from the United States.
So we're talking about 700,000 people
Potentially,
then, right?
yes.
Wow. And
certainly the immigration attorneys in Los Angeles are arguing that forcefully in front of the immigration judges.
okay, so it's my understanding too, I mean, I'm an ex-prosecutor, although before they had these notice to appear, but the notice to appear started in 1997. So let's say you have somebody and they've been ordered deported. Some of them maybe are still in the US, some have been deported. Could those cases be reopened and terminated?
I mean, certainly we will argue, as well as other immigration attorneys should be arguing, that yes, the judge never had jurisdiction to order them removed from the United States. You could file a motion to reopen. Now, the problem with motions to reopen is that there are certain deadlines that you have to meet that's associated with filing a motion to reopen. But if you argue that this is a significant change in the law, then I think you do have a pretty valid basis for filing at least a sua sponte motion to reopen, which would be a motion to reopen, basically asking the court to exercise its discretion to reopen your case in light of the significant change in the law that we see in this case.
So this sounds unbelievably huge to me.
Yes, it is. It is.
Okay.
I mean,
yeah.
I believe that it is for sure.
So, I mean, if any of you are under deportation proceedings or you have a friend or relative, I mean, this is like kind of the ultimate Christmas gift to them. I mean, this decision, and as I understand it, it was an 8-to-1 decision.
That's right, which is very rare nowadays.
Right. Well, so why don't you go ahead and explain Mr. Pereira's case, and then from there we'll take it to how it affects others.
Okay, so Mr. Pereira, from what I recall, was a visa overstay, and he was detained on a DUI, I believe it was, and that was prior to him reaching the 10 years that he had of continuous physical presence in the United States. So he was served with, he was put into DHS custody and served then with the notice to appear in immigration court, but that notice did not specify the time and place of his proceedings.
Okay.
I believe that it took the Department of Homeland Security about another year before they actually filed the notice to appear in court. And then once the court had the notice to appear, what it does is it issues a notice of hearing. So, sir, please appear at this. In other words, it's called a notice of hearing, and it just basically says this is the time and the day that you're supposed to appear in immigration court. And what happened in his case is because so much time had elapsed between the point where DHS served him with the notice to appear and then filed it with the court, there was an issue with his address, right? I don't recall if it went to the wrong address.
Right,
It never reached.
Exactly. So he wasn't notified.
Right. So he never got the notice, and he moved to reopen based on and he was ordered removed. When you don't go to immigration court, you get ordered deported in your absence. So he moved to reopen his case based on the fact that he never got notice of his proceedings. It was reopened. And then once he was before the immigration judge, his attorney argued that he was eligible for cancellation of removal, which is a form of relief for people who have 10 years of continuous physical presence in the United States and have certain qualifying relatives and meet other requirements and are not barred by criminal activity.
And I understood by that time he had 2 daughters who were U.S.
Right,
citizens,
and he
right?
at that point had met the 10 years, I believe, by the time he was in removal proceedings. But what the court ordered him removed anyways, finding that he wasn't eligible for cancellation because his notice to appear had been served on him before he reached the 10 years.
So isn't that what they call the stop time rule?
That's what they call the stop time rule. So
and why did he try to get this reopened in front of the judge?
He did try to get it reopened, and it was reopened.
No. I mean, when my understanding is in 2013 when he was picked up for some traffic offense.
Right.
And they reopened the case, put him before the judge. He asked for cancellation of removal, and he said no. Mm-hmm. And then afterwards, he tried to. He appealed that, right?
He appealed that decision.
And what did the Board of Immigration Appeals
And so
say?
the Board of Immigration Appeals sided with the judge and said that so it doesn't matter. I mean, there's case law on the Board of Immigration Appeals. I think it's a case from 2011. I don't remember the name. But it says,
Castillo.
It says basically the stop time rule applies to cut off your continuous physical presence, whenever you're served within an NTA, even if the NTA doesn't specify the time and place.
And so what did this attorney do when the Board of Immigration Appeals rejected it?
So then they filed a petition for review, and I think it was with the First Circuit Court of Appeals.
And in Massachusetts.
Right.
Yeah.
And so, but again, I believe the First Circuit also sided with the board. And basically the First Circuit said, well, the statute is ambiguous, so, we'll apply Chevron deference, which is probably more than you need to know. But because the statute is ambiguous, we are going to defer to the board's interpretation of the statute.
Right, because they're the experts, right?
Right.
But the Supreme Court said, well, we only defer when the statute is ambiguous.
Right.
And when you look at the 96 law that created the notice to appear, it lists about 8 different things that the notice of appear has to say, and one of them is you have to put the date and time of the hearing, and they didn't do that. So 8 of the justices, 8 out of 9, said, well, there's nothing ambiguous about that. It says the date and time. They didn't put the date and time. And in fact, in the last 20 years, with a very few exceptions, the government never puts the date and time on the notice to appear. So that means almost everybody who's been under deportation proceedings from 1997 till now could move to either reopen or terminate their cases. Even under, tell me whether you agree with me, but even under a very narrow reading of the case, if you just apply the facts of Mr. Pereira and the fact that they said, well, the stop time rule doesn't cut off your 10 years if it doesn't show the date and time, there's probably so many people that went into deportation proceedings in the 90s and the 2000s, a few years ago, that now have 10 years in the US. Could those people get it reopened just like Mr. Pereira? I mean, we're not going any further than that. And apply for cancellation of removal now in front of an immigration judge.
Yes, we believe that. Yeah, I mean, that's what Pereira, I mean, my interpretation is that's what it stands for.
I think that's pretty clear. I don't, the government doesn't like that, but I don't think the government can argue with it. I mean, that is exactly what the majority decision says. We link to it from our page, by the way, the majority decision. We have a Supreme Court page, but right now it's up on breaking news and so on. So when you apply for cancellation of removal, how long is it going to take a judge to actually be able to decide whether you get it or you don't get it?
Well, it's going to take a while because there's only, so cancellation of removal, there's only like 4,000, I believe, visas.
No, but what I'm asking though is how long before you get your hearing before the judge and present witnesses and all of that?
Again, a while. I mean, it could take a while.
How long's a while? You're here in LA. So
we're looking at, I mean, I was in one judge's courtroom yesterday. She's setting merits in 2020. So a master calendar hearing, like you're talking about an initial master hearing, like after it's reopened and they get set. Probably
the hearing on the merits.
The hearing on the merits, we're looking at potentially 2020.
Okay, and I've heard sometimes longer, like 3 years.
Mm-hmm.
No, if
It depends on the judge's docket.
Right, but if every one of these cases, let's say there were 100,000 of these cases, and I think that might be a low estimate, if they had to put cases they've already decided back on the calendar because the stop time rule is not going to apply, the 3-year wait could go to a 4 or 5 year wait.
That's right. That's right.
And what I want to point out is when you apply for cancellation of removal, in a few months after that, you get a work card. So all these people, and you may be one of them, but all these people who've been ordered deported from the United States and now can apply for cancellation of removal because the stop time rule is not going to apply to them. They'll have to give them new NTAs. There are going to be 100,000 people that'll have work cards to work in the United States, right?
Right.
Okay. So if you are somebody who just, to break it down, to make it really easy, and by the way, I should say that, in our firm, just because of this decision, for people that are affected by the Pereira decision, during the month of July, if you make an appointment with one of our deportation specialists, either Attorney Sotelo or Jennifer, I never can say her name right. Can you say her name right? Rodzelsky. Jennifer, just call her Jennifer. We're not that formal in our law firm. But if you make an appointment with them, and you can do it by just calling us up at 213-623-4592, pressing 0 for the receptionist, and she will mail you a form to fill out, and then just send it back to the receptionist. It'll be reviewed by either Attorney Sotelo or Jennifer, okay? And if they think you fit into the Pereira decision, then you will get a free consultation during the month of July, because we really think this is going to help a lot of people, and we don't, we have a pretty high fee for making an appointment because otherwise we'd be buried with this. But this is so important that I think it's really necessary to just waive all the fees. We're willing to take the hit for that and just get people who we can help get their cases terminated or reopened before the immigration judge, to do it quickly and to get you work permits, okay? But is it possible that this may, and by the way, I should mention, because we haven't had anybody ask, but if you're watching this Facebook Live, which we'll later put up on YouTube in the next, probably over the weekend, but if you have any questions about it, this would be a great time for us to answer the questions. If not, we'll just keep going on.
I do see that there are some comments over there. I just wonder if you could click on that.
Oh, okay. Let's see. Oh, yeah, we do have comments. They just, okay. Oh, it's just, no, they're likes. Thank you for, 6 people have liked us while we've been talking.
How about,
but, yeah,
sorry, we're not very technologically
yeah.
here.
How
about the one to the right? 16 comments, do you see that?
Oh, okay. Yeah, sorry about that. Oh, yeah, we are getting a lot of comments. They just didn't show up. So let's go over the comments, and then we'll talk about the more.
We did get a thumbs up emoji, so thank you.
Okay, Lisa, nice to hear from you. Lisa's one of our friends. She's an immigration attorney from Olympia, Washington. We have Wanda. Hi, Wanda. And let's see who else. Ecode, hello. Mr. and Mrs. Khatib. Okay, let's see what else we have. Alexandra, what about form over substance being a no-no? What about the unclean hands? What about correct address being required? I'm not quite sure exactly.
Yeah, I'm not quite sure about the question. What is the question asking?
Yeah, I mean, if anybody has unclean hands, it's the U.S. government, because they have not been following the law for the last 20 years.
That's
and now
right.
The Supreme Court says, slap on the hand, you sit in the corner.
Right.
And so they brought this all on themselves.
Right, and I do also want to say, Alexandra, that before an immigrant is required to notify the immigration court of his or her address, they have to be properly served with a notice to appear right before the consequences of potentially an absentia order would attach to them. So we're talking about even before the immigrant is supposed to update the court or let the court know of his address. They have to be served with a notice to appear, and the Supreme Court has very clearly said that's a notice to appear in removal proceedings. It does not specify the time and place, is not a notice to appear under the statute. So, the fact that they did not later update their address with the court, or they didn't receive the hearing because of that, well, our argument is that they were never properly served with a notice to appear. So, that obligation never attached to them. So, that's the next step. But the first initial step is you have to get a notice to appear that complies with the immigration statutes as the Supreme Court has interpreted them.
Yeah, I can almost guarantee you that now that this decision's come out, even though I haven't seen a notice to appear in the last week, a new one, that despite whatever the government attorneys are going to argue, they are going to tell the people at USCI or at DHS that every notice to appear must have the time and date, because they would be crazy not to do that.
Right.
And I used to be one of them. They are not crazy. They are representing the side that wants to deport people.
Right.
But they're lawyers. They're smart. They understand the law. So I think that in the future, notices to appear will have the time and date, because they know, we who are representing immigrants are going to try to terminate all 700,000 of these cases and reopen and terminate the ones for people who've been deported or who are ordered deported but never left in the last 20 years.
Right, and then I also want to just add that I have heard that and I have not seen it personally, but I have heard in certain courtrooms that DHS attorneys are trying to basically handwrite the date and time of the hearing where the respondent is presenting themselves in. And the immigration judges have asked immigration attorneys to brief the issue of whether the DHS can basically cure a defective notice. And the way I read the decision, you can't, because they're saying it's not even a notice to appear to begin with, right?
Exactly.
It's not incomplete, and that's what the dissent. Alito tried to argue, like, oh, this is just an incomplete notice that can be, cured and fixed. It's not a notice to appear. I mean, that's the basic premise of this.
Somebody who's been doing this
case
forever, here's what I find kind of interesting. The reason, the 96 law that established the notice to appear and the stop time rule, which had never been part of the law before, because before that there was something called an order to show cause, and I was one of the government attorneys, and if somehow back then it wasn't 10 years, there was something called suspension of deportation, where you could apply for a green card, and the suspension of deportation only required 7 years. So what a lot of people would do, and why they made it restrictive in 96, is attorneys would use this. I remember sitting in court one day, Judge Robertson, who was a great judge, and the attorney whose client had been in the U.S. for 6.5 years, the attorney said, well, we're not ready to pursue the case. We'd like a 6-month extension. And I opposed it, but the judge granted it anyway. And I said, Judge, why would you grant the case? And he said, well, Mr. Shusterman, this is a KLAP case. And I said, what's a KLAP case? He said, KLAP stands for keep as long as possible, because they know that if their client can get over the 7-year mark, even though they've been served with the order to show cause, then they can apply for suspension of deportation. And they're so close, I'm just going to give them that. But some of the real restrictionist members of the House of Representatives and the Senate said, no, we don't want attorneys to do that anymore. So they established this stop time rule that as soon as you're served with a notice to appear, even if you're one day away from the 10 years, it's like, sorry, you're out to lunch. And what I find funny about this is what you're saying about what the government attorneys are doing and, handwriting things on the NTA. Seems like a KLAP to me. It seems like the other side's doing KLAP now, right?
Right.
So I don't know whether this will ever come before the Congress, but I can tell you, as people, lawyers who've been fighting for immigrants all these years, like we have, we're not going to tolerate KLAP. If they do that, we're going to press forward with these cases and not. I think I called a bunch of attorneys in North Carolina and New York, other places yesterday in preparation for this. And it seems like the strategy is starting to go nationwide, that the government attorneys are telling the judge, well, let these people brief the cases, meaning us, okay? And then give us 60 days to respond, because otherwise there's going to be 20 different theories. The trial attorneys for the government in LA will say one thing, San Francisco something else, Chicago something else. So they really need to meet and come up with a common strategy. But I don't think any strategy is going to prevent people from being able to reopen where there's no date and time on the NTA and apply for cancellation of removal, because that's exactly Pereira's case. The Supreme Court has decided it 8-1. So for those 100,000 people, I mean, whether or not you'll ultimately get a green card through cancellation of removal depends on the nature of your case and the hardship. But what I can assure you is that you'll probably buy between 3 and 5 years. We submit the application, we ask for a work card, and then you and your spouse will get work cards. And the kids who are not U.S. citizens but are, sufficiently old enough to go to work. And who knows? There could be another president in office before you even get the hearing. And I'll tell you, I mean, this is political, but you cannot deport 11 million people from the U.S. I just don't think that this administration, either they're just talking the talk and they're not walking the walk. I mean, President Obama actually deported more people per year than President Trump. It might surprise some of you. Some of the organizations called him the deporter in chief, and he was. But, we do have laws in this country and they have to be enforced. And he said, look, I can deport maybe up to 400,000 people a year. So I'm going to concentrate on the people that are the biggest dangers to society. And he went after hardened criminals, and not somebody like, Mr. Pereira, who had a drunk driving offense, although frankly, that happened in Obama's time. Yeah. But mostly, it was like 90% of the people were criminals with felonies or drug crimes or some serious offenses. I think that once we start reopening these cases, that 3-year wait could very possibly go to a 4 or 5 year wait.
Yeah.
And so, we eventually, I think Congress is going to have to be practical and is going to have to reach some kind of consensus, like, we're going to build the wall or we're going to have more people at the border. But the people who are already here and are not criminals, we're going to give them a work card and eventually let them legalize. And it's not because of some ideology, it's just because of practicality. We're the richest country in the world, and we have a border with a country that's a lot poorer, has high unemployment. And when we go out to a restaurant, when we go to a hotel, the rates would be higher, except that the people that are making our lunches, making our dinners, taking care of our kids, doing incredible amounts of things for the economy, a lot of them are undocumented, and to have hearings and get each person deported, we don't have enough resources. I mean, if everybody wants to raise their taxes, double their taxes, maybe we could deport all these people. So I think I'm old enough to remember the It's called the Immigration Reform and Control Act that a very conservative president, Ronald Reagan, signed in 1986, and it resulted in 3 million people being legalized. And I think we're on the cusp of that, although with this administration, it's probably not going to happen, but with the next one, they're just going to be forced to make a deal on immigration. But this will not only help the people that are under deportation proceedings, but when we start reopening all these cases and terminating the cases, every case we terminate, I would expect the government to come back immediately and issue a notice to appear all over again.
Well, I mean, yes. So there's some argument that you cannot file a second notice to appear.
Tell us about that.
No.
Okay.
And I have seen that. A shout out to Stacy Tolchin, because she was the one who said it on the Los Angeles County Bar's listserv, but immigration listserv. But I suppose, and I didn't really want to say this, but the government's attorney could argue that, okay, if it's not a notice to appear, then here you go, here's your notice to appear, right? The first one that we're going to file, because according to Sotomayor, but then they've accrued all this physical
they'll say the
presence
first
at that
one
point.
wasn't really a notice to appear,
And so then they might cut off their time.
They might be able to, do that.
Right.
Yeah.
But nevertheless, I want to add that in light of all of the negative news coming out of the Supreme Court, with the travel ban, because that was pretty devastating, and then also with Kennedy's retirement, we don't know what's going to happen with this. This is a very exciting case and gives us a sliver of hope a huge piece of hope as immigration attorneys that something could go our way. And I'm very excited about it. I really believe in fighting for these people, because the vast majority of the folks that I represent are very, very good people. They've made mistakes, but they're overall very good people. And I love helping them, and I love doing this stuff. So I really encourage immigration attorneys to look at this case, study it, and fight the good fight for your clients, because this is a fantastic case. And not all the immigration judges are agreeing. I just want to let you know, but fight it. Fight it, because I think the language is pretty clear that we have a very strong case.
I mean, they're not these people who disagree, they're not the last word, because they disagree, you appeal it. I mean, you can't go above the Supreme Court, and the Supreme Court's already told us that the stop time rule isn't going to apply, and these notice to appear are not valid because they didn't include the date and time. So I don't think there's anything to fight on those 100,000 people. We're going to move on in a minute to just a short summary. And by the way, this will be in our July newsletter, which will come out on Monday. So, if you haven't signed up for that, it's a free newsletter that we've been putting out for 23 years. So I would say it's at least worth the money. So go ahead and subscribe. But we do have a question from Maria. It says, all news for the illegal one, and no one does anything for those who've applied legally. Well, I mean, actually, we do stuff for people who applied legally and are still waiting to be called, like me. A petition was filed in 2007, and my son is still waiting to get called for an interview. Seems to me that the illegal ones are better off than... Well, probably because you haven't been in deportation proceedings, because you'd be losing a lot of sleep, Maria. But let me just point out, I can't speak for everybody in the country, but I can speak for myself. Congress did pass a law in 2002 called CISPA, the Child Status Protection Act, and it was for people that are here legally and going through the regular system. And what happened is a lot of the waiting times, like my wife is from the Philippines. When we met when we both worked for the Immigration Service in the 70s, and when she applied for her brothers and sisters, doing everything the legal way, number one, if you have a brother and sister, you're a citizen, you have brothers and sisters in the Philippines, the waiting time is 24 years. But that's the good news. Can you believe that? That's the good news. The bad news is that before this Child Status Protection Act, if your kid turned 21 during those 24 years, that's a little ridiculous, isn't it? Then the kid was screwed. So you wait 24 years, you can get a green card to come from the Philippines to the U.S. I think Mexico is about 20 years or something, and most countries are about 13 years. So you can imagine how many of these kids age out. They turn 21. So the Child Status Protection Act created certain protections for the kids, but there was one clause we call it the automatic conversion clause, and it said that if you had a right to retain your original priority date, but to automatically convert to the appropriate category. So the Immigration Service, my old bosses, took that clause and interpreted it so restrictively that it applied to almost nobody. And I guess because I'm old and crabby, I was the one who went to the federal district court and challenged their interpretation of this so that people could bring in their kids. So we're talking about people who are doing it legally. And to make it short, at the Ninth Circuit Court of Appeals, we had an en banc decision before 11 judges. I argued it online, the video's online, and we actually won, but just barely, by 6-5. And the government, in their great wisdom, took this to the Supreme Court, and by a 5-4 decision, overruled that. So, I just want you to know, I feel your pain, Maria, but it's not like, we're just trying to help illegals and not people who are doing it the legal way. In our firm, we have one attorney who does family-based immigration, one attorney who does investor immigration, EB-5s, 2 attorneys who do employment-based immigration. So most of our attorneys are doing it for people who've done it the legal way. But for these people in deportation proceedings, there are still some rights that they have. And the government was the one who did it illegally back in 19... Yeah. They said, oh, no, we're not going to... If you read my blog on this that I put out last week, you'll see they put out a decision, and Giselle wrote an article for the LA Daily Journal, which is out today, the legal newspaper, saying this, that in 1997, the Attorney General just totally flipped the law and said, oh, we're not going to put out the date and time.
Right.
Well, you can't do that. It's the law. So, if anybody's out there is upset about, the people that have overstayed their visas or come illegally to feed their families and help us, get lunches that are cheaper and hotel rooms that are cheaper, and I'm not condoning that, but I'm just saying the law permits them to apply for certain things. And it is actually the Department of Homeland Security that broke the law and said, and the Attorney General, the Justice Department, and said, oh, we don't care what Congress says. We're not going to put the date and time. And now it's come back to bite them. So anyway.
I think we do have more comments. I'm not sure if you want to.
Oh, do we have more? Oh, my God. I'm sorry. We're, like I said,
think we just need to.
Oh, just scroll up?
Scroll up.
No, that can't do that. But it does say 33 comments.
We're not seeing all of your comments, unfortunately. I'm not sure what.
And I think we don't want to make this too long.
Yeah. Certainly, we have free consultations, right? Yeah, we're not seeing all of them.
Yeah. Okay. But let's just spend 5 minutes, and we will have some follow-ups to this Pereira, because this is a huge decision. So in a week or 2 weeks, we'll have another thing where you can ask your questions. But so we know that, let's say, these 100,000 people who've been here over 10 years and either are still in deportation proceedings or have been ordered deported or had their cancellation applications denied or didn't even submit them, they can benefit. But let's just spend 5 minutes before we stop just talking about people who maybe they don't have they don't have qualifying relatives, they don't have the 10 years in the United States. But if the notice to appear doesn't have the date and time, I think their lawyers can just ask for those to be terminated.
Right. As
we said, the government will probably issue new NTAs, but that a lot of people may have other things they can apply for besides cancellation of removal. And by the way, as Giselle pointed out in her article today, there's two kinds of cancellation. There's one for non-permanent residents, basically for undocumented people, and they have to be here 10 years, be a person of good moral character for 10 years, and have exceptional and extremely unusual hardship to certain qualifying relatives, which are citizen or permanent resident children, spouses, or parents, okay? And remember, you know, even if you think your hardship doesn't meet that very high standard, you can still apply, and it's up to the judge to make a decision. And if you're not happy with the judge's decision, you can appeal it to the Board of Immigration Appeals. So you will be on that work card for years while you're fighting this out. But let's say I don't have the 10 years and I've been ordered deported with a NTA that didn't put the date and time. And last week I just married a US citizen. I just married my girlfriend. Is there any relief for people like me?
Well, I mean, certainly you would want to adjust status if you entered the United States lawfully, right?
Okay.
So somebody like Mr. Pereira, who was a visa overstay, by marrying a U.S. citizen, you become an immediate relative, and you can get a green card through your spouse, through your U.S. citizen spouse. You don't need to meet any sort of 10 years of physical presence to qualify for that, and that is something that you would try to reopen your deportation order, saying, the process is basically you say, I am now eligible to adjust status in the United States because my circumstances have changed, right? And so if you're outside of the 90-day deadline for motions to reopen, then you have got to request DHS join, right? In that instance, to get around the fact that you do not meet the deadline. Or you can argue sua sponte, right? Please, judge, now that I'm married to a U.S. citizen, if you would please allow me to adjust status. I don't have any crimes, yada, yada. So yes, you can also ask to reopen just to terminate, and then your case based on Pereira, and then try to get your, so that would basically, by reopening and terminating, gets rid of your removal order, and then you adjust status, get your green card with USCIS.
So what we're trying to point out, and we're going to end this in a minute, is that even besides the situation that Mr. Pereira was in, if your situation diverges from that, you have a different thing. So you may be marrying a U.S. citizen, that's sort of an obvious thing, but you may be eligible for cancellation of removal as a permanent resident, which only requires 7 years in the United States. You may be eligible for a waiver of deportation. You may be eligible for asylum. There may be a whole host of things that you may be eligible for. So what I would urge everybody in that position to do is see a deportation, an attorney like Attorney Sotelo, who specializes in deportation defense. We don't expect all our clients to be lawyers, out there. And just see if you're eligible or not. And since we're doing free consultations, it's worth your money, right? To do that.
For sure.
So thank you for sticking with us. Like I said, we'll post this video. If you have friends who didn't get to listen in, we'll put this online, and we'll have a follow-up within a couple of weeks. Thanks very much.
Thank you.
Okay.